sustainability context. You're very numerous today, so we're quite happy about that. I'll give a very brief introduction and let me start with positioning this webinar. As you probably know, we at the Shift, we work on a few themes. One is human rights, another one is biodiversity. We have work and inclusion, and via our backup project, we also work on the climate topic. But in fact, this webinar is sort of a transversal topic, and we group these around the it sounds a bit ambitious, maybe, around the name of reinventing capitalism. So under that subject, we bring some topics that do not fit in one of our specific themes, but are a bit more overarching. So today we are very happy to welcome Anne-Sophie Pieke, who is partner at CY, and she will bring us an introduction to what's happening in the sustainability context from a regulatory point of view. You may be aware that sustainability, or at least that's what we are experiencing, is moving higher and higher on the agenda, not only of corporate entities, but also of governments and the European Union. And in that context, quite a number of topics have turned up. Some have very weird names. You probably all heard about the Green Deal, but there's also CSRD, NFRD, and it's these things that Anne-Sophie will help us position and give an overview. So Anne-Sophie, I'll stop sharing my screen and I give the floor to you. Thank you very much, Anne-Sophie.
Thank you, everybody. Hello. I will try to share my own screen. Let me see if it works. Is that okay? Can you see them?
Yes, that's fine, Anne-Sophie.
Okay, thank you. So it's really a pleasure and an honor for me to be with you this morning. The purpose of my presentation is to give you a rapid overview of the last regulatory development in the sustainability context at European level, but also at national level, if we have time enough to go through. There is a lot to say, the legislator working hardly on this topic, but I will do my best to go through the most important subjects. Let me first introduce you the general context. The impact of human activities on the environment, on climate, on geology has dramatically increased. The extraction of non-renewable resources has reached record levels, and the pressure on our ecosystems has never been so severe. Those two aspects have mobilized society and policymakers as they could trigger a complete collapse of our societies, climate change, and to a lesser degree, reduction of biodiversity. In the last few years, and even recently 2 weeks ago, reports of the IPCC continuing to call for accelerated action to reduce greenhouse gas emission and move towards a more sustainable economy. In that context, the EU adopted, as you know, the European Green Deal in December 2019 and announced several far-reaching reforms to ensure that the private sector and especially companies play also a significant part in achieving this objective and contributing to a more sustainable economy. The overarching objective of the EU Green Deal is for the EU to become the first climate neutral continent by 2050, resulting in a cleaner environment, more affordable energy, smarter transport, new jobs, and an overall better quality of life for all of us. The main elements of the EU Green Deals are, as you can see on this slide, climate action, clean energy, sustainable industry, buildings and renovation, sustainable mobility, eliminating pollution, farm to fork on the agricultural side, preserving biodiversity, research and development, and preventing unfair competition from carbon leakage. To achieve the goals set by the European Green Deal, the Commission has pledged to mobilize at least €1 trillion in sustainable investment over the next decade, and that money cannot come from public investment only. The Commission aims also to channel private investments towards the transition to a climate-neutral economy. In that context, and in order to support the European Green Deal, the EU has issued its Sustainable Finance Action Plan, the SFAP, to promote sustainable investment across all the Union. And the SFAP has three main objectives that you can find on the slide: to reorient climate flow toward sustainable investments and away from sectors like fossil fuels, manage financial risk stemming from climate change, resource depletion and environmental degradation, and foster greater transparency. And that SFAP includes 10 key action plans that you can find on this slide. On that action plan, the EU has put in place 3 building blocks for a sustainable finance framework. Those building blocks are a classification system, so a taxonomy of sustainable activities, a disclosure framework for non-financial and financial companies, and investment tools, including benchmark, labels, or standards. I propose that we follow those 3 building blocks to go into the details of some of the major EU regulatory initiatives. But before, I wanted to rapidly refer to the new EU Sustainable Strategy that has been issued in July 2021. Considering that since the publication of the action plan, the understanding of what is needed to meet the SDGs, the Sustainable Development Goals, has evolved, and with the pandemic, the global context has changed. The EU Commission has issued a new phase of the EU Sustainable Finance Strategy. These new strategies identify 4 main areas where additional actions are needed for the financial system to fully support the transition. And those main areas are financing the transition of the real economy, more inclusiveness in the sustainable finance framework, improving the financial sector resilience, and fostering global ambition at international level. And you can see on the right side of the slide new type of action that have been identified in the context of this new strategic plan. But let's go back to the first building block, the taxonomy. The taxonomy regulation aims to provide a robust, science-based classification system allowing non-financial and financial companies to share a common definition of what is sustainable and thereby providing protection against greenwashing. The objective of this taxonomy is to create a framework for evaluating economic activities based on 6 environmental objectives that you can see in the bullet, the green and the yellow bullet on the left side of the slides. Those 6 environmental objectives are mitigation of climate change, adaptation to climate change, sustainable use and protection of marine resources, transition to a circular economy, prevention and reduction of pollution, and protection and restoration of biodiversity and ecosystem. An activity can be considered sustainable if it substantially contributes to one of these 6 environmental objectives without causing significant harm, that's the DNSH, do not significantly harm, to one of the other 5 objectives. An activity must also meet basic social criteria to be considered sustainable, those basic social criteria being the alignment with the OECD guidelines for multinational enterprise or the UN guiding principle on business and human rights. The European Commission has instructed a group of experts, the Technical Expert Group, known as the TEG, to set criteria for selecting activities that contribute substantially or to mitigation or to adaptation to climate change, the two first objectives, with the bullet, the blue bullet, and this among 67 different sectors of activities. A first delegated act on the climate component of the European taxonomy has been adopted in June 2021. The text established the technical criteria for the two first environmental objectives, and at that time did not cover the nuclear energy sector nor the gas one. After 2 years of discussion, the European Commission proposed a new supplementary delegated act on December 31st last year, and that was adopted by the Commission on the 2nd of February 2022. The classification now includes gas and nuclear energy, which, according to the EU Commission, have a role to play in facilitating the transition to renewable energy and to climate neutrality. The text will now be sent to the European Parliament and to the Council, which have 4 months to express any objection, and 2 months extension can be requested by those two bodies. In the absence of objection, the delegated act will enter into force and apply. That will mean that those two energy could be integrated into the labeling system, which aim to guide private investment in sustainable activities, and that investment in gas or nuclear power plant could in the future be classified as sustainable. The European Commission has set several conditions for nuclear, electricity and gas, but I will not go into the details. You can find them in the delegated act. And recently, yesterday or the day before, we have seen several entities asking to the Commission for not accepting to include those two energy sector into the taxonomy. The taxonomy concerns several actors, financial supervision institutions such as the central bank, insurance company, etc. Member states that put in place public measures, standards or labels of green financial products, and finally companies with more than 500 employees who will have to indicate the proportion of their turnover, their capex and their opex that correspond to activities which are eligible to the taxonomy starting in 2022, so this year. Here is a slide with the template that need to be used by the company to report alongside the taxonomy. I did say that they need to report on the turnover, capex and opex for activities which are eligible to the taxonomy. There is indeed a difference to be made between eligibility and alignment. The eligibility of an activity implies that this activity is included in the delegated acts on climate change mitigation or climate change adaptation, the first two objectives for which a delegated act has been published. Whether this activity is taxonomy eligible or not say nothing about the sustainability or the unsustainability of that activity. Being taxonomy eligible is merely an indication that a certain activity makes a substantial contribution to one of the 6 environmental objectives of the taxonomy. The alignment, on the contrary, implies that an activity complies with the requirements enumerated, especially for this activity in the taxonomy, including the do not significantly harm criteria. It's only when an activity is complying with those technical screening criteria, the do not significantly harm criteria, and the minimal safeguard linked to this activity, that the activity is aligned with the taxonomy. But let's go with an example. On the left-hand side, you find a list of activities which are included in the Delegated Act on climate change mitigation and/or climate change adaptation. Let's take the construction and real estate sector of activity, and in that one, the subsector of construction of new building. To see if, as a building company, your activity is eligible to the taxonomy, you need first to look at the NACE code and the global description of the activity. That's what I put under the number 1. Then, secondly, to check whether you contribute to the climate change mitigation, for example, by renovating buildings according to the stricter requirement. That's number 2. To check whether your activity is aligned with the taxonomy, you go further on step 3 and make sure that your activity does not significantly harm to the other environmental criteria described under the number 3 in the Delegated Act then, but that you can see on the slide under number 3, and meet the minimal social safeguard. An example, in the IT sector, the process is the same. As you can see, it's quite complex, and it's the reason why the EU Commission has put in place the EU Taxonomy Compass that could help users to check which activities are included in the EU taxonomy and then is eligible, to which objective they substantially contribute, and what criteria they have to meet to be aligned. On the next steps, delegated acts for the 4 remaining environmental activities should come before the end of the year. At least it's what the EU Commission promised. Moreover, on last 28th of February, the EU Platform on Sustainable Finance published its final report on social economy. The current social taxonomy, sorry, the current taxonomy is only focused on environmental, but we know that there is something which is coming on the social side as well. The European Commission has asked the platform to advise it on whether, to what extent the EU taxonomy could cover social issue. So there is this first final report, and we will see what the Commission will do with it in the coming months. The second building blocks is around the disclosure obligation for non-financial and financial companies. Here is a global overview on what we mean by the EU sustainability disclosure regime for non-financial and financial company, but let's start with the financial ones. The first action that has been taken by the European legislator was to impose new disclosure obligation on certain large companies, and that was done by the Non-Financial Reporting Directive, the NFRD, dated 2014, that imposes on certain large public interest entity an obligation to publish a non-financial statement. Belgium, the NFRD has been transposed by the law of 3 September 2017, and which amends section 3.6 of the Belgian Code of Company and Association and imposes an obligation to draw up and publish a non-financial statement to public interest entities. This non-financial statement must contain information relating to at least environmental issues, social issues, personal matters, respect for human rights, and the fight against corruption, to the extent necessary for an understanding of the business, the performance, and the situation of the company and the impact of its activity. The statement can be published in the management report or in a separate report, and in its non-financial statement, the company must publish a description of the company's activity, the policies applied by the company, including the due diligence procedure that it has implemented, the result of these policies and the main risk associated with those issues, the way in which the company managed these risks, and key performance indicator attached to these topics. For such indicators, Belgian companies are invited to rely on European or international benchmarks such as GRI, TCFD, SASB, or the SDGs. In June 2017, the European Commission published guidelines to help companies disclose environmental and social information. These guidelines are, of course, not mandatory, and companies may decide to use other kind of guidelines. In June 2019, the European Commission published additional guidelines on climate reporting, which refers mainly to the TCFD. And I invite you to go to the study that has been done by the FSMA on the current way Belgian listed companies comply with this obligation. And in that report, you can also find some best practice. In April 2021, the European Commission announced that the NFRD would be replaced by the Corporate Sustainability Reporting Directive, the CSRD. In the explanatory memorandum, the Commission presents the reason why there was a need to amend the NFRD, and I quote it. Investors want to better understand the risk of and opportunities afforded by sustainability issue for their investment, as well as the impact of those investments on people and environment. The current legal framework does not ensure that the information needs of these users are met. It is because some companies do not report such information, while many that do report sustainability information do not report all the information that is relevant for users. When information is reported, it's often neither sufficiently reliable nor sufficiently comparable between companies. The information is often difficult for users to find and is rarely available in a machine-readable digital format. So that's all the reason why the EU Commission decided to come with a new proposed directive. Under this new text, the scope of targeted undertaking and the scope of the required disclosure will be extended. Indeed, the reporting requirement should apply to a broader range of companies, including all large companies listed or not, and all listed companies, including SMEs. That is the scope in the draft text, but we will see that for SMEs, things are changing a little bit with the Council position that was issued a few days ago. Article 2 of the proposed text intend to impose the double materiality reporting. So companies falling under the scope should include in the management report information necessary to understand the company's impact on sustainability matters, but also information necessary to understand how sustainability matters affect the company's development, performance, and position. The CSRD also expands the mandatory content of the management report. It should contain a brief description of the undertaking's business model and strategy, the resilience of the company's business model and strategy to risk related to sustainability matter, the opportunities for the company related to sustainability matters, the plans that have been put in place by the company to ensure that the business model and the strategy are compatible with the Paris Agreement, how the company's business model and strategy take into account the interest of the stakeholders and of the impact of the company on sustainability matters, how the company strategy has been implemented in those topics, a description of some targets, and a description also on some indicators. And finally, a description of the roles of the administrative body, management and supervisory body regarding those matters. The other principal novelties of the CSRD is that it requires external assurance of the sustainability information. It means that external auditors or other kind of external body will have to have a look to the sustainability information. It imposes forward-looking and retrospective reporting, so there is no possibility anymore to do it on a comply or explain basis. It imposes also that information is published in the company management report. And so no more, there can be no more separate report. It has to be disclosed in a digital machine-readable format, and it requires company to report in line with some mandatory EU sustainability reporting standard. Those standards should be, EFRAG is working on those, on the establishment of those standards. So EFRAG has been mandated by the EU Commission to put in place those standards for the E, for the S and for the J. And those reporting standards should be in line with the EU Green Deal, but also in line with the current standard that we know and that I already mentioned before. The last development on this CSRD are the following. As I said, the Council has just finalized and published its general position on the CSRD, while the Parliament seems to be close to doing so, and the ambition remains, of course, to try to conclude the trilogue under the French presidency, so before June 2022, because the French presidency has put this initiative on the top of its list. The Council agrees that the CSRD should include all large companies and SMEs listed on regulated markets, which would be subject to a proportionate regime, but exclude SME listed on MTF, so non-regulated market, and SMEs growth markets, as well as unlisted SMEs. So that's a difference compared to the original proposal. And non-EU companies operating in the single market should be left out of the scope as well. The Council's position considers the adoption of reasonable assurance by external auditor only 6 years after the entry into force of the CSRD. The deadline for the implementation by company have been revised as well and would apply to the financial years starting from January 2024 for large listed companies, January 2025 for large non-listed companies, and January 2026 for listed SMEs. On the financial side, there is the SFDR. The Sustainable Finance Disclosure Regulation, SFDR, aims to provide more transparency in terms of environmental and social responsibility within the financial market. The regulation applies to both investment firms and financial market products. It imposes in particular on financial actors, financial market participants, the obligation to provide clear and precise information in terms of the positive or negative effects that his investment choice may have on social and environmental criteria. It's also, and above all, a regulation which aims to harmonize the information which must be disclosed in commercial documents by those financial market participants, the final objective being to allow investors to have the information that they need to better orient themselves towards more responsible investments. The SFDR regulation provides for 3 categories of investment products: Article 6, Article 8, Article 9. Article 6 are products, investment products that have no sustainability objective at all. Article 8 is investment funds and products which integrate environmental and social characteristic, even if it's not the central point of the investment process. So we should say that's the green light products. And Article 9, products and investment funds that have a genuine sustainable investment objective, the green dark. Under the provision of the SFDR, the financial market participant must, as from last 10th of March 2021, publish information on how sustainability risks are taken into account in their investment decision-making process or their investment advice, the consequence of their management decision and or their advice on sustainability factors, so again, the double materiality effect, and information concerning their remuneration policy and how this policy is consistent with the integration of sustainability risk. This slide you can find in a nutshell an example on the way BNP Paribas Fortis complies with its obligation regarding SFDR by publishing a lot of different information on its website. This slide tries to summarize the link between the three main regulations, taxonomy, which is applicable to both companies and market participants, CSRD to companies only, the future CSRD, because it's still a draft, and the SFDR. The third building blocks is a set of investment tools, including benchmark, standards, and label. These make it easier for financial market participants to align their investment strategy with the EU's climate and environmental goals. They provide greater transparency to market participants. For example, the EU Climate Transition Benchmark and the EU Paris-aligned benchmark created by the EU Climate Benchmark Regulation go in that direction. But let's see the Commission proposal for a standard on European green bonds, which is still as well a draft. What is a green bond? I suppose that you are familiar with this product. In a nutshell, a green bond is a fixed income instrument specifically designed to raise funds for climate and or environmental projects. The European Green Deal underlined the need to better direct financial and capital flow to green investment, as I said, and the Green Deal announced that the Commission would establish that EU GBS because green bonds play an increasing important role in financing assets needed for the low carbon transition. So far, there was no uniform green bond standard within the EU, and that's the objective new standard. It's a voluntary standard to help scale up and raise the environmental ambition of the green bond market. Once it is adopted by the co-legislature, the proposed regulation will set a gold standard on all companies and public authorities can use green bond to raise funds on capital markets to finance large-scale investment while meeting sustainability requirements and protecting investors. This new EU GBS will be open to any issuers of green bonds, including companies, public authority, and also issuers located outside of the EU. There are different key requirements under the proposed framework. The funds raised by the bond should be allocated fully to projects that are aligned with the EU taxonomy. So there is a link between the two texts. Full transparency on how the bond proceeds are allocated through detailed reporting requirements. All European green bonds will have to be checked by an external reviewer, and those external reviewers will be supervised by the ESMA, so the European Security Market Authority, that will ensure the quality of the standard. A summary on where we stand with the EU GBS, which is still a draft. Rapidly, other initiatives which have been taken at European and national level. It's important, I think, that we say a word about sustainable governance. We know there are already some quite old texts on that, in that respect. In 2024, the EU adopted a directive aimed at addressing significant environmental damage, such as damage to protect species and habitats, surface and groundwater and lands. That's the Environmental Liability Directive, which has established the polluter pays principle. A second directive was adopted later on, complementing the first one by criminalizing some serious violation of environmental legislation and requiring effective, proportionate and dissuasive sanction by the member states. In May 2021, the EU Parliament pushed for a revamping of those two texts and recommended revising and transforming them into a fully harmonized regulation framework that would apply to all companies operating in the EU. So far, we didn't see anything. The European Green Deal and the Action Plan set out that sustainability should be further embedded into the corporate governance framework because too many companies still focus too much on short-term financial performance compared to the long-term development and sustainability aspects. To properly integrate sustainability into corporate strategies, the Commission announced that it will carry out consultative work on the possible needs to legislate in this area. There were two different studies. EY was in charge of the study on directors' duties and sustainable corporate governance. It concluded that there has been a trend in the last 30 years for listed companies within the EU to focus on short-term benefits of shareholders rather than on the long-term interest of the companies. The study argues that sustainability is too often overlooked in favor of short-term financial motives and that to some extent corporate short-termism finds its root cause in the regulatory framework and the market practices. The study concluded that an EU policy intervention is required to lengthen the time horizon in corporate decision-making and promote a corporate governance that is more conducive to sustainability. The study has been largely and unanimously criticized, mostly on the assumption that shareholders are short-termist. A second study was done on the due diligence requirements, and there as well, conclusion was taken that there is a need to take some legal initiative. Parallel to those two studies, the EU Commission launched a public consultation aiming at collecting the views of stakeholders and has announced a sustainable corporate governance initiative for 2021 that we didn't see. And I will come back on that later. In March 2021, the European Parliament adopted a resolution formally requesting the Commission to propose that legislation and the Parliament did publish draft text for a directive on corporate due diligence and corporate accountability. This draft is aimed at ensuring that companies operating in the EU fulfill their duties to respect human rights, environment and good governance, and do not cause or contribute to potential or actual adverse impact on these topics through their own activities or those directly linked to their operation, product or services by a business relationship or in their value chain, and that, if any, they prevent and mitigate those adverse impacts. The value chain is defined in a very broad way and includes all activities, operation, business relationship and investment chain of a company and includes entity with which the company has a direct or indirect business relationship upstream and downstream. Finally, the proposal of the EU Parliament recommends that member states should ensure that they have a liability regime in place under which companies could, in accordance with national law, be held liable and provide remediation for any harm arising out of potential or actual adverse impact on human rights, environment, and governance that they or other companies under their control have caused or contributed by acts or omission. So it's quite broad. After more than 230 days, finally, and after having postponed it sometimes, the EU Commission published last 23rd of February a proposal for a directive on corporate sustainability due diligence. The proposal is certainly less ambitious than the one of the Parliament, and the notion of sustainable governance has disappeared. In a nutshell, EU companies with more than 500 employees on average and a worldwide net turnover exceeding 150 million will be within the scope of the full due diligence obligation. It's the so-called Group 1. EU companies that do not fulfill the criteria of 500 employees, but have more than 200 employees and on average, and more than 40 million worldwide net turnover, and which operate in one or more high-impact sectors, would be required to comply with more targeted due diligence, focusing on severe adverse impact only. For this company, the rule will start to apply after a transition period of 2 years to allow for a longer adaptation. The selection of the high-impact sector for this directive will follow the OECD due diligence guidance and will include sectors such as textile, agricultural, extraction of mineral resources, etc. Those companies are the so-called Group 2. Non-EU companies active in the EU with turnover threshold aligned with Group 1 and Group 2 are included in the scope as well. All of the turnover that need to be taken into account needs to be generated in the Union, with no detail on the way this turnover should be calculated at this stage. SMEs, including micro enterprise, are not in the scope, but they will, however, be impacted by the directive as contractor or subcontractor of companies which are in the scope. To support SMEs to implement due diligence, the Commission suggests that Member States should set up and operate dedicated website, portals or platforms and provide financial support to help them build capacity. Obligations are numerous and cover the need for companies to include due diligence in all their policy, identify and prevent, seize and or mitigate potential and actual diverse impact, establish complaint procedure, communicate, remediate, etc. These steps are in line with existing international soft law standards such as the OECD that I already mentioned. To ensure the effective enforcement of the due diligence duty, the directive provides for a combination of sanction and civil liability. The proposal also introduced directors' duty to set up and oversee the implementation of due diligence and integrate it into the corporate strategy. Rapidly, at national level, in Belgium, the concept of the social interest of a company has been, heavily debated in both doctrine and case law for several decades. That debate mostly focused on two contrasting definitions of the social interest. The first centered on the common patrimonial interest of the shareholders, more or less in the long term, and the second added to the common interest of the shareholders, the one of other stakeholders such as employees, clients, creditors, society, etc. Broadly speaking, and without considering the many topic of the debate, this implies two different corporate models. The first, often labeled Anglo-Saxon, is shareholder-oriented. while the second, called Eurocontinental, considered that a company must be managed taking into account the multiple interests that are impacted by its activities. While recognizing that the difference between those two models should not be caricatured, one can wonder if tackling the environmental crisis will not definitively tilt the balance in favor of the second model. The recent legislative initiative at European and national level clearly points towards obligation for companies to act in the interest of all their stakeholders and the society at large. In Belgium, the Corporate Governance Committee published a first Belgian Code of Corporate Governance for listed companies in 2024. The committee was asked to regularly review the code's provision to ensure their consistency with practice, legislation, and international standards. The code was reviewed in 2009 after the financial crisis and more recently in 2020. In 2020, the revision of the code was the opportunity for the committee to place emphasis on sustainable value creation. This involves an explicit focus on the long term, on responsible behavior at all levels of the company, and on the permanent consideration of the legitimate interest of stakeholders, not only in the preamble of the code, but directly in some of the principles. And I invite you especially to have a look to the new principle 2.1 and the new principle 2.2. Like other governance code in the world, the Belgian code now integrates a sustainable dimension and the long-term role of the companies. The Commission has also published an explanatory note on sustainable value creation, defining what is sustainability and what is sustainable value creation, considering that there are 6 items that are conducive to such a long-term value creation. And I invite you to have a look to this explanatory note. In Belgium, there are some draft laws on the table of the Parliament. There is one amending the Code for Companies and Associations, aiming at integrating a carbon footprint in the annual report of companies. This project, dated 2019, as I said, is still pending. There is also a motion for a resolution to include the crime of ecocide in the Rome Statute of the International Criminal Court and in the Belgian criminal law, dated 2020. There were some discussion at the Commission level, the Parliament Commission, so more to come on that one. And the third one is a draft law establishing a duty of vigilance and a duty of responsibility for companies throughout their value chain. It proposes to impose a duty of care and accountability on all companies throughout their value chain. The scope of this draft law is wide, since it intends to apply to all companies active or established in Belgium, with a view to prevent Belgian companies from moving abroad to escape their new obligation, and foreign companies active in Belgium to be subject to less strict standards, causing unfair competition. The draft law requires large companies to develop a vigilance plan comprising a mapping of risk, a procedure to assess subsidiaries and subcontractors, as well as an alerting and a reporting mechanism. The proposed law would also create a specific civil liability regime for breaches of the duty of care. The draft law is also still pending before the Parliament, waiting for the EU initiative, but know that the Commission has issued its proposal, things may change. Rapidly, in our neighboring countries, in France, which is the more advanced country, there is an interesting law relating to the duty of vigilance that has been adopted in 2017 that requires French companies which directly or indirectly employ at least 5,000 employees in France and foreign companies that employ more than 10,000 employees in France to establish and publish a vigilance plan to prevent risk in terms of environment and corruption, but also human rights in their own activities and those of their subsidiaries, subcontractors and suppliers in France and abroad. The plan is supposed to be developed in association with all the stakeholders of the company and has to be made public. This new law has already been used before the court. For example, the Tribunal de Nanterre has decided in February 2021 that it was competent to judge the compatibility of the total group vigilance plan with the Paris Agreement. There is a new law that has been inspired by the proposal of the Citizen Convention for the Climate established by Macron further to the Gilets jaunes movement, which is the Climate and Resilient Draft Law adopted in May last year. Interestingly, this draft law contains several provisions aiming at trying to make advertisement much responsible. So there is, for example, a prohibition for any promotion of fossil fuel and also the creation of code of conduct that need to be used by the Conseil supérieur de l'audiovisuel in order to significantly reduce commercial communication relating to goods and services that have a negative impact on the environment. In the UK, two pieces of legislation have recently been introduced. The first, called the Bribery Act in 2010. Corruption is sanctioned in all of its forms, whether passive or active, private or public, local or foreign. This law is innovative in that it targets not only individuals, but legal persons as well for failure to prevent corruption and make this punishable by an unlimited fine. The second law is the Modern Slavery Act, which requires commercial companies with a global turnover of at least 36 million GDP that carry out business even partially in the UK to produce a slavery and human trafficking statement for each fiscal year. The statement must contain details on the steps that the organization has taken to identify and eradicate modern slavery, both in its own business and in its supply chain. In the Netherlands, a recent law dated September 2019 imposes on any companies that sells goods or provide services to Dutch final user to perform due diligence to prevent the production of those goods or services through child labor. Organizations have the duty to investigate their supply chain, to publish a declaration of due diligence, and if the investigation reveals a suspicion of child labor, to take action. And finally, in Germany, the Cabinet of Ministers of the Federal Government has just launched a new bill to ensure better human rights protection in the supply chains. This new law will apply as of 2023 to companies with a workforce of at least 3,000 employees, and later to companies with a workforce of at least 1,000 employees. It requires those companies to ensure compliance with human rights along their entire supply chain. Environmental destruction is also covered by the law, such as illegal deforestation, inappropriate use of pesticide, contamination of water, etc. It's interesting to note that the German government justifies the law by explaining that companies in Germany earn money from items produced in other parts of the world. It is why they also bear responsibility for ensuring that human rights are respected along their supply chain. The legislation on corporate due diligence in supply chain is to obligate German companies to better meet their global responsibility. To conclude, within the ESG context, we see that European and national regulations are gradually shifting from a model based on transparency obligations, so duty to report, to one that creates substantive due diligence and other obligation, the duty to act. Under the current rules, companies are merely required indeed to report and disclose, while EU and Belgian proposed legislation will require companies to act, for example, by conducting diligence on ESG impact throughout the company's entire value chains. As a consequence, stakeholders, court and regulators will be able to hold companies and their directors legally accountable for adverse impact on the environment and social and human rights. But at the end, in fact, duty to report, duty to act, isn't it both sides of the same coins? At least they are complementary. Stakeholders, investors, regulators on one hand will only be able to assess the effectiveness of companies' action if there is a comparable, reliable and relevant sustainable reporting in place. And companies, on the other hand, will only be capable to appropriately disclose information without engaging in greenwashing to the extent that their actions are effectively and properly carried out. And at the end, corporate sustainability is not only driven by compliance with law. Other aspects, other stakeholders need to be taken into account. Investors, in particular institutional ones, are increasingly demanding sustainable reporting. Indeed, investors are shown a growing interest in company ESG performance that is not limited to compliance with legal rules, as investors are generally also looking for best-in-class behaviors. In the absence of a list of minimum key performance indicators, investors based usually their decision on the rating granted by extra financial rating agencies. Institutional investors put direct pressure on companies to change their behavior. The general meetings, for example, of the major oil groups have become the place for intense debate on energy transition. Increasingly well-equipped and better informed on the issue, activist shareholders are demanding more commitment for those companies to ensure their ability to achieve carbon neutrality. Legal actions are also initiated by clients, NGOs, local authorities, as we have seen in the various actions against public authorities. In several countries, citizen associations, NGOs, have launched legal action against the government on the basis of a large gap between their commitment and their action. See, for example, the Klimaatzaak in the Netherlands or l'affaire Climat in Belgium. Other categories of stakeholders will also put pressure on companies, such as the consumer, who, via social media, may boycott the use of products or certain shops if they consider that the company does not behave in the right way. Expectation of staff and competition to attract talents increasingly in search of meaning is also to be taken into account. The Big Four experience, for example, huge difficulty to attract young people nowadays. And we have seen that more than 1,100 employees at consulting firm McKinsey signed a letter during the spring 2021 calling for the company to do more to encourage its clients, many of whom are amongst the most environmentally damaging companies, to cut their emissions. The open letter called on McKinsey to not only redress its own emission, but to also publicly disclose the carbon that its clients produce in aggregate and commit to helping them to cut their emission in line with meeting the Paris Agreement 1.5 degrees targets. Several of the letter's authors have since resigned from McKinsey. Banks are urged to review their credit policy by the central banks, requiring them to assess both their physical and transitional climate risk. Banks are thus pushed to sort out their financing and to prioritize sustainable and long-term investment. And for this, they will need information on the policies put in place by companies in this area. And if this information is incomplete or non-existent, there is a great risk that the financing will not be. Finally, companies may decide to put pressure on their suppliers to reduce the carbon footprint of their entire value chain. All of this changing environment has to be taken into account regardless of the size, form of the company or the sector in which it operates. And with that last slide, I thank you.
Okay, thank you very much, Anne-Sophie. I knew you were very knowledgeable on this topic, but you have, even so, you have impressed me. And I think for some participants as well, this was a big chunk of information to grasp. We have some time for Q&A. Before we jump on that, two small messages as well. First of all, Katrien will at some point in time now during the Q&A put a survey in the chat, a satisfaction survey on the event. So before you leave, make sure you fill this out, because if you do, we plant a tree for every answer. So that's an incentive for everyone present in the webinar to let us know what you thought of this. And also, before you leave, I would like to make a small announcement. On the 31st of this month, we have a physical event that will deal with the topic of the new due diligence regulation. Mr. Kittil will be present. There will be another high-profile guest available, which we can't announce for the moment, but have a look in our agenda. There's a very interesting event on the due diligence topic at the end of this month. So together with Katrien and obviously with you, Anne-Sophie, we will go through some questions. I'll start with the one from Beatrice. You did reply to it in your slide, but I think it would be good to repeat on this. When will the CSRD be applicable? From what date onwards do organizations have to report according to CSRD?
If we go through, if we have a look to what the Council has proposed, it will be 2025 for the large listed company, 2026 for the non-listed companies. There were different dates, so they postponed a little bit what the Commission has proposed. Let me go back to my note. I think it's 25th for the listed companies and 2026 for the non-listed companies. Yes.
Okay.
So let's see. Of course, the trialogue is not finished, so it may happen that the Parliament come with other things, and the negotiation is still in place, so we never know. But at least that's the proposal from the Council.
Katrien, next question.
Yeah, Beatrice added also a question regarding the fact that it can not be separate reports. So has it to be combined with the annual one?
Yes.
Annual
so today it's possible to have two separate reports: the annual report and the sustainable one. In the proposed CSRD, it has to be in one unique report. Why is it so? It's to be sure, because it's part of the management report, that it means that the management itself is taking the responsibility of what is in that report. So it's the reason why the Commission has requested that they form only one document.
Okay. Clear, I think.
Okay, there's a question from Wim Vermeulen. The EU is apparently preparing a directive on the sustainability claims that businesses can make. Do you know anything about this directive?
maybe we is referring to the last proposal that I described, which is the sustainable due diligence one, because in that one, indeed, it's foreseen that member states should put in place a compliance process against companies that have seen things which do not work appropriately in all their value chain. So normally member states should put that in place. Of course, that corporate sustainability due diligence draft is really at the beginning of the process. It's the first draft that has been proposed by Commission. Now there will be consultation, there will be discussion with the stakeholders and then the trilogue. So we are far from the final text. Let's see what will happen.
Two questions, in fact, regarding the educational institutions and also all the large impactful non-profit. Do they have to follow the CSRD, or is it in question or not? So non-profits?
Non-profit, no. For the timing, the Corporate Social Reporting Directive, as I said, the scope will be broader than the non-financial reporting directive. So it will be all listed and non-listed large company with a threshold which is currently at 500 employees, which may be lower to 250. That's not finalized yet. And all the SMEs which are listed on a regulated market. So the NGOs are not in the scope.
And neither educational institutions?
No.
Okay.
Of course, on a voluntary basis, it's still possible to follow what is in the CSRD. And as I said, because banks, for example, will ask for some information to continue to finance some small companies or some project, it may be interesting for companies which are not in the scope of the CSRD to nevertheless publish information on what they do in terms of sustainability, because banks may decide not to invest in that company or not to lend anymore to that company because there is no information available. So there is, on a voluntary basis, it can be, it's still possible, of course, for companies to follow the text, to follow the obligations.
Okay. Then there's two rather technical questions, I would say, on SFDR. So SFDR for a private equity firm based in Belgium with funds all over the world, how do they have to deal with non-EU funds? Are they in or out of scope for reporting? Or if that's too technical?
I'm not a specialist on the SFDR. Maybe I will take the question from me and I will come back.
Okay.
If you don't mind.
Yeah, and then a similar question, but maybe a bit less technical.
Maybe that person could have a look. Sorry to interrupt, Bart, but maybe that person could have a look to the FSMA, which did provide for some guidelines on the way SFDR has to be put in place in Belgium. So maybe they can find some information there.
Yeah. And then a similar question is if holding companies need to comply with the SFDR, are they considered financial market participants?
Not as far as I'm aware.
Okay, no. So that's a clear answer.
Now a question about the double materiality remains difficult to understand. And the question is, are there framework available to conduct in a company?
You can find some guidelines in the one that I provided, which are linked to the non-financial reporting directive. The one dated 2017, I think they provide some guidelines on what we mean by double materiality. But in a nutshell, is to be sure that the company do report on the impact its activity has on its environment, and on the contrary, what is the impact of its environment on its own activity. It's really to make the link between the two. That's what we mean by double materiality. And it may happen that in the context of CSRD, where double materiality is really in the text of the directive and not in in a recommendation or in the guidelines that the Commission may issue some guidelines afterwards on that in that respect, because it's something which is very, very important for the Commission.
Okay, there is a question, if I'm not mistaken, it's from Elia. What about companies active in several EU member countries? Do they have to disclose non-financial information according to CSRD requirements in several reports, so on a country level as well as on a group level?
It should be done at the group level, and so
it's only group level. Yeah, okay.
Maybe a question also about the difference between Belgium and EU directive. Does the draft law on duty of responsibility in Belgium go further than the recent EU directive on corporate sustainability due diligence in terms of applicable companies?
Yes, because the text of Belgium, the Belgian text applies to all companies active in Belgium. So you want to know if the scope is different compared between the text of the directive and the text of the...
Right, yeah.
Yeah, of course, the Belgian law can only be applicable to Belgian companies, or at least to outside foreign companies active in Belgium. And the text of the European directive is broader than that, because it is for the European. But because it's a directive, it will have to be implemented in each of the countries. So maybe the draft law that exists in Belgium will be the starting point of the one implementing that directive in Belgium. It's true that a lot of persons were disappointed by the text of the last proposal coming from the Commission. Not only because it doesn't focus on governance anymore, but also in terms of scope and obligation for companies. Let's see what will happen.
Okay. There's what I personally find a very interesting question here. Are traditional corporate governance bodies still adequate to meet all these sustainability expectations? And should maybe new bodies be created? You have quite a bit of experience in that area, Anne-Sophie.
Yeah, new body, I don't know what it could be. So far, I consider that the liability of the board didn't change, and it's still the common responsibility that is applicable, even if the subject that have to be taken into account by the board when they take some decision is broader. They have to take into account the environmental part, the social part, the human rights part, even if in the past it was already the case, but they didn't realize maybe that it was. So there is no change in the liability of the board today. It may change if the new directive comes into effect and that it has to be implemented in the law, because that directive asks for each member state to put in place a specific liability regime linked to the duty to care. So that may change the situation in the Belgian law, but so far it's not the case. So for me, there is no need to create a new body. Saying that, we see, but I don't know if it's the kind of new body that the person is referring to, we see in some companies that they create a dedicated committee of the board, which is a sustainable committee, and that will be the one leading all the process to embark the sustainability journey into the company. And as soon as it is done, we can consider that that committee is not needed anymore, and all the subjects are again at the level of, are discussed at the level of the board. That's sometimes a new body that is created in some specific company, but not in all of them.
And why would you consider that a temporary body, Anne-Sophie?
Because it's really to start a process. It's really time consuming, effort consuming. So it can be easier to really have a small body conducting that journey into the company, making clear that there is a stakeholder engagement to be done, a materiality matrix to be done, to see how you will, on a top-down basis, include sustainability in all the organization. And so that can be led more easily with a small committee that could be a sustainable committee that will, of course, inform the board on their progress. And when all the process is in place, there is maybe less necessity to keep that body in place, because at the end, sustainability could be embarked in the long-term strategy of the company, and that it's clearly something that is in the hands of the board.
Another question is the EU really a pioneer on increasing ESG requirements on companies, or what about other continents, countries around the world?
EU is certainly a pioneer, or at least, and wants to continue to be the leader in that area. Of course, the European Commission knows that they are not alone on Earth, and so they are continue to speak with other continents. We know that there are other kind of taxonomy, for example, which have been built in the US, in Asia, in Canada, and the idea of the fourth area of progress to be done in the context of the new EU strategic plan that I proposed was to improve the international cooperation, because of course there is it's better if everybody is aligned with the same kind of requirement, or at least that we can understand each other on what is sustainable and what is not, for example. So there are discussions at international level, but it's not the reason why EU doesn't want to be the leader.
All right, then again, some more technical question from Jan de Nul. Does the taxonomy have to be a part of the financial report, or can it be included in the general/integrated report?
I suppose he refers to the obligation for company this year to include turnover, capex and opex. It can be in the integrated report, but it has to be clear. So first of all, the analysis has to be done. Do we have taxonomy eligible activities? And then what is then the capex, opex and turnover percentage of related to this kind of activity? And he can use the format that I proposed. Not all the companies are doing so. Some are using another kind of chart, but next year when the taxonomy, when it will be the alignment that will have to be reported, the template will be mandatory. So, but this year it's possible to not use it and to do it in a very simple chart with the percentage of activity, the percentage of turnover, capex and opex that are related to these kind of things, activity. So integrated report, it can be done there. But again, maybe to add something, it has to be discussed also with the external external auditor, I suppose, that will have a look to this reporting.
Okay, maybe also a small technical question also. Will the EU law replace all existing laws in the different countries? It's about what's a directive, I
But
think.
if it's a directive, it's a little bit strange that for the last one, the one on due diligence, it's a bit strange that the Commission at the end took the decision to issue a directive instead of a regulation, because the objective is to harmonize the situation across EU, and at the same time, a directive, as we know, has to be implemented in each of the countries. So it may happen that we will have differences across the member states that we have already today with the different laws that I mentioned on due diligence. The number of employees not the same, so the scope is not the same. The notion of value chain may be different in one country or another. So it's a little bit a pity that we are confronted to a directive instead of a regulation. So no, it will not replace the member states' laws, because the member states' law will have to implement the text of the directive.
But maybe that's a bit of a difficult question. Charlotte is asking, can you share some best practices from perspective taxonomy and SFDR? Some front runners. I'm not sure, Anne-Sophie, if you can comment on that, or.
But on the taxonomy, it's really difficult because it's the first year that companies need to apply it. So I think that all the companies trying to obtain best practices and to see how we have to implement it. And it's true that it's not so obvious. As I said, the taxonomy is very complex, and so the best is, I think, to discuss this with his external auditor to see if, because they see different sector, different type of companies, so they can maybe have some advice on that one. Next year it will be different, because at that time we will have maybe more clarity on the way companies have fulfilled their duty. So sorry, so far I don't.
So maybe next year we can invite you again, Anne-Sophie, and you can present some best practices.
Yes, and maybe FSMA will also have a deep look on that this year when all the annual report will be published. It may happen that they make a report again, an analysis on the way Belgian companies have fulfilled their obligation. So that's, I don't know, I'm not I don't know if the FSMA will do it or not, but it should be great if they can also publish some best practices on that in that respect.
Yeah. Okay, Katrien, if I'm not mistaken, we have more or less come to the end of the questions. I see some very nice comments towards you, Anne-Sophie, on the content. What I was also thinking, because as somebody said in the comments, this is indeed a vast topic. We were also very surprised by the number of participants or registrations for this event. If, as a member of this shift, you think this is something we should maybe do in more detail, or build a community of practice around it, let us know. We're happy to discuss. We do this for and with our members. So if you think, even if we do this in a smaller group, we're happy to see how to proceed with this. This was a first test. As I said, we would like you to reply to the survey, which Katrien posted in the chat. Chipo, our colleague Chipo, also posted the link for registration to the event on the 31st of March. You won't be disappointed. We will have some high-profile guests there. So this is the time to leave your house and quit the bad habit of webinars. And we would like to see our members real life as well. So thanks very much, Anne-Sophie. We are 3 minutes in advance. It was really very interesting, and I hope it was the same for you as well. So
yes, thank you to all of you, and thank you for inviting me. It was really nice to be with you this morning.
okay, thank you very much. Bye-bye.
Bye-bye.